If you own a gun in America, everything you thought you knew about your rights just changed. A federal appeals court dropped a bombshell ruling this November that's reshaping gun laws across the country. There are 10 massive changes in this decision, and some of them will shock you. These changes open up new freedoms while creating legal traps you never saw coming. Hit subscribe right now because missing this could cost you everything. Here are the 10 changes every gun owner needs to know immediately. Law 1. Strict scrutiny as the mandatory standard. This first change is the foundation that makes everything else possible, and it flips how gun laws work in America. For decades, courts let the government defend gun restrictions without proving they were truly necessary. The November ruling says every single gun law in this country must now survive what's called strict scrutiny, the toughest legal test there is. Anytime the government wants to limit your gun rights, they have to prove three things. First, they need a genuinely compelling reason, not just a good policy idea. The government carries the full burden of proof, and that puts thousands of gun laws nationwide in real danger of getting tossed out. But here's something even more important that hits your wallet directly, and almost nobody is talking about it yet. Law 2. Civil liability shield for lawful defense. If you ever have to use your gun to defend yourself, this next change could save you from financial ruin. For years, people who lawfully defended their lives with firearms still got wrecked in civil court. A guy in Ohio shot a burglar breaking into his house at 2 a.m. No criminal charges were filed. The burglar's family sued him and won $400,000. A woman in California defended herself from an attacker in a parking lot. The attacker sued her for $1.2 million, claiming excessive force. The November ruling creates broad immunity from civil lawsuits. When you use a firearm in lawful self-defense, the criminal who attacked you can't sue you for their injuries. The burden shifts entirely onto anyone who tries. They have to prove your actions were criminal before a civil case can even move forward. But there's another change that affects whether police can even take your gun in the first place. Law 3. Law Enforcement Accountability Standard. Officers who violate your gun rights are now facing consequences they didn't have to worry about before. For decades, something called qualified immunity insulated officers from personal responsibility, even when rights were clearly violated. That shield just got weakened for Second Amendment violations. Under this November ruling, officers can't hide behind qualified immunity when they violate clearly established gun rights. If they take your legally owned firearm without probable cause, they can face personal liability. In Virginia last month, an officer confiscated a man's concealed carry handgun during a traffic stop, even though the man had a valid permit and disclosed it properly. The officer just got hit with a $300,000 personal judgment. This creates real accountability that protects you from illegal police actions. Still, there's a specific type of place where the rules just changed dramatically. Law 4. Sensitive place restrictions narrowed. The government's favorite trick for banning guns everywhere just got shut down hard. States like New York, New Jersey, and California came up with a workaround. They couldn't ban guns outright, so they labeled almost every public location a sensitive place where guns were prohibited. Some states built lists with over 50 categories of banned locations. The November ruling blows up that strategy. The court created a strict two-part test for what actually counts as a sensitive place. A courthouse with metal detectors and armed guards qualifies. A school with security screening and police officers qualifies. But a public park with nothing but a sign that says "No guns" isn't a sensitive place anymore. Private businesses can still ask you to leave if they discover you're carrying, but they can't have you arrested just for being there. States are being forced to cut their sensitive place lists by 80% or more. But getting permission to carry in the first place used to be its own nightmare. Law 5. Carry permit processing timeline. The bureaucratic game of delaying your rights until you gave up just ended. For years, states with restrictive gun laws would take your carry permit application and then just sit on it. 3 months, 6 months, a year. New York had applications pending for 18 months on average. The longer they stalled, the more people quit and stopped pursuing permits. Every state must now approve or deny your carry permit application within 60 days of submission. If the state doesn't respond within that window, your permit is automatically approved by default. States can't demand extra documents after you submit unless there's a specific legal deficiency they identify in writing. The 60 days starts when they receive your application, and it doesn't stop. If your application is denied, they must give a detailed written explanation citing specific legal grounds. Several states already report they've approved more carry permits in the last 3 weeks than they did in the previous 6 months combined. But carrying legally only matters if you know what you're actually allowed to keep ready. Law 6. Ammunition storage mandates struck down. The rules that made your gun useless in an emergency just got wiped off the books. Several states passed ammo storage requirements that sounded reasonable, but were designed to make firearms ineffective for self-defense. Massachusetts required ammunition to be stored in a locked container, completely separate from your firearm. California mandated ammo be kept in a different room from your gun. A county in Illinois required ammunition and firearms be stored on different floors of your home. Think about what that means in a real emergency. You go to your safe and get your gun. Then you have to run to another room, unlock a separate container, load your firearm, and hope the intruder waits patiently while you do all of it. The ruling says ammunition storage mandates that prevent immediate access violate the Second Amendment by rendering firearms useless for self-defense. You have the right to store your firearms and ammunition together in whatever setup makes sense for your security needs. The government can't dictate how you store ammo in your own home. But that raises a bigger question. Were states keeping records of what you bought in the first place? Law 7. Firearm Registry Prohibition Enforcement. The gun registry that wasn't supposed to exist just got exposed and ordered dismantled. Federal law has banned a national gun registry since 1986. It's explicitly illegal for the government to maintain any system that tracks which firearms are owned by which people. But several states looked for loopholes. California's dealer record of sale system contained information on every handgun purchase going back to 1996. That's 20 million records linking specific people to specific guns. Hawaii required every single firearm in the state to be registered with local police, including make, model, serial number, and the owner's personal information. The November ruling calls this out and orders it torn down. Any state-level database that tracks individual gun owners or specific firearms is illegal and violates federal law. These systems must be destroyed within 180 days. Every state that maintained them must send written confirmation to affected gun owners that their information has been permanently deleted. Several states are already challenging this, but the court made it clear. Non-compliance can trigger contempt findings and daily fines until registries are eliminated. Still, there's a specific license that was being used like a weapon against gun owners. Law 8. Federal Firearms License Reform. The ATF's favorite tactic for crushing gun businesses just became illegal. For years, the Bureau of Alcohol, Tobacco, Firearms, and Explosives used federal firearms license rules like a hammer to shut down dealers they didn't like. They'd show up for inspections hunting for any tiny mistake in the mountain of paperwork dealers are required to keep. A transposed digit in a serial number, a missing check mark on a form from 3 years ago. A gun store in Pennsylvania lost its license because the owner wrote 2022 instead of 2023 on a single form. A dealer in Texas had his FFL revoked because he used blue ink instead of black ink on transfer documents. The decision says the ATF can only revoke a federal firearms license for an actual criminal violation, not mere administrative mistakes. The ATF must issue a written warning and give reasonable time to fix honest errors before taking action. This levels the playing field for small gun businesses and stops regulators from using licensing as backdoor gun control. But protection at home means nothing if you can't take your gun with you. Law 9. Concealed carry reciprocity expansion. Crossing state lines with your gun just became dramatically simpler. For decades, concealed carry permits were stuck in a confusing patchwork of state-by-state recognition. You could have a valid permit in Georgia, but the moment you drove into Florida, that permit meant nothing. Gun owners had to check reciprocity maps before every trip and pray the info was current. People got arrested at traffic stops because they didn't realize their permit wasn't valid 20 miles across the border. The November ruling creates a national baseline for permit recognition. If you hold a valid concealed carry permit from any state, at least 42 states are now required to honor it. Your Texas permit works in New Mexico. And the ruling says states can't pile on extra requirements for out-of-state permit holders. If your permit is valid in your home state, it's valid in 42 other states, period. You can drive across the country with your concealed firearm and stay legal the whole trip. Officers in states that used to reject out-of-state permits are being retrained right now. But even with reciprocity, there was still one situation that scared gun owners more than anything else. Law 10. Enhanced Castle Doctrine protections. Using your gun to defend your home used to mean preparing for two fights, one against the criminal and one against the prosecutor. Even in obvious self-defense situations, district attorneys in certain jurisdictions pushed hard charges against homeowners who shot intruders. People who survived violent home invasions ended up facing murder charges, manslaughter charges, or assault with a deadly weapon charges. The burglar was armed with a crowbar and had a violent record. The homeowner was arrested on scene, charged with aggravated assault, and spent 2 years fighting the case before being acquitted. A woman in Maryland shot an ex-boyfriend who kicked in her front door in violation of a restraining order. She was arrested, charged with attempted murder, and spent 8 months in jail before the case was dismissed. The November ruling shifts the burden of proof in home defense cases onto the prosecution. If you use a firearm to defend yourself in your home or on your property, prosecutors must now prove beyond a reasonable doubt that your actions were not justified self-defense. These 10 changes represent the biggest shift in gun rights we've seen in generations, and they affect every part of how you own, carry, and defend yourself with firearms. The difference between knowing these rules and getting blindsided by them could be the difference between freedom and a courtroom. If this information just saved you from a legal disaster you didn't see coming, smash that subscribe button and hit the notification bell so you never miss an update. Share this with every gun owner you know, because these protections only work when people actually understand they exist.